of arbitration. We have 5 guests here, and first each of them would present their systems very briefly. Then I would raise some questions related to the control of costs and also some questions related to the cost calculations. Then let us begin with our colleague Azzali, and then I would continue. Yes, it is your turn, please.
Thank you. Very briefly, the system of, let's say, cost control in Milano with the Milan Chamber of Arbitration, I believe it's not very different than the systems applied by many other institutions. We have a schedule of fees that is related to the value of the disputes as it has been stated by the parties. So there is parties pleadings, and the value of the dispute is the sum of the claimant request and an eventual counterclaim. The sum of the two makes the value of the dispute. Then we have scales of fees for the arbitrators related to the value, and a scale of fees for the institution. Of course, the dimension is different. Then we ask the parties advance on cost 50-50. If it is not paid, the arbitration cannot proceed, and that's a system that is applied, I would say, by all the major institutions. What we do, actually, we do not ask the parties to a high deposit to start with. What we do, we rather ask the parties a portion of the advance on cost related to the activity performed by the arbitrator. So it takes, maybe we deliver 2, 3, 4 requests to the parties along the proceedings, just along the activity performed by the arbitrators. So we don't request 100% in advance. That's what I mean. As I said this morning, we do offer the parties the possibility to ask for bank guarantees rather than cash deposit, and it's something that has been used more and more, and I believe I understand why. Once the arbitration starts, we have also the practice to give some of the money collected to the arbitrators. That, again, something that not all the institutions do. Many, they wait for the end of the arbitration to pay the arbitrators. We don't do it. We do it along the proceedings, immediately after the hearing for the formal constitution of the arbitration. Again, along the proceedings, if there is any failure of payment, we first ask the other party to pay. If no one pays, then we suspend the case, the proceedings, and after a certain period, we can consider the request for arbitration retired. It's an option we don't do quite often. Most of the time there is a dialogue with the parties if they are late on advance payment, but it's a principle that we want to guarantee. It's a guarantee for the arbitrators and for their activity and their performance. What else? As far as the allocation of cost, it's not our business. It's a business of the arbitrators, so that's something we do not control. I would say that more or less these are the main features. I would not take much of your time. I'm sure that when the Ergun will make questions, I will have the opportunity to go into details, but I think that for now it's enough just to give you more or less the features, the main features of our system. Thank you.
Okay. Thank you, Stefano. The second speaker, Mr. Farid Ben Belkacem, is from Algeria, so he is arbitration committee's member of the Center of Conciliation, Mediation and Arbitration at the Algerian Chamber of Commerce and Industry. So, dear colleague, it is your turn. Yeah.
Thank you. Alors, ici, excusez-moi, mais je vais parler en français. Je parlerai doucement pour pouvoir mettre une bonne traduction. Alors, tout d'abord, je voudrais remercier aussi bien notre ami Stefano et notre ami pour avoir organisé cette manifestation. C'est avec beaucoup de plaisir que le centre d'Alger assiste. Pourquoi ? Parce que nous sommes là pour apprendre, nous sommes là pour essayer de voir qu'est-ce qui marche et qu'est-ce qui ne marche pas dans l'arbitrage en Algérie. Donc, ça serait une approche plutôt pragmatique et empirique, et ça sera aussi une sorte de monographie sur le cas algérien, parce qu'en Algérie, actuellement, il y a un seul centre d'arbitrage, et c'est cette expérience que j'ai essayé de vous délivrer pour bien comprendre comment se passe l'Algérie. Mais ce n'est pas tellement le problème de l'arbitrage que je retiendrai ici, ça sera surtout l'objet de notre conférence, c'est-à-dire les coûts de l'arbitrage, et j'essaierai de rester dans le timing qui m'a été demandé. Alors, il est difficile présentement de faire une présentation académique sur les coûts de l'arbitrage en Algérie, tant au niveau de l'arbitrage interne que de l'arbitrage international. Cela tient au fait que l'arbitrage institutionnel n'est toujours pas développé et qu'il existe encore une certaine réticence vis-à-vis de ce moyen de règlement alternatif des différends commerciaux. Certes, il y a une nouvelle loi qui est, depuis 2008, c'est le Code de procédure civile et administrative qui a mis, si vous voulez, en application l'arbitrage, et il y a un article 1006 qui consacre le principe de l'arbitrage. Donc l'arbitrage est permis actuellement, parce que je dis actuellement, pourquoi ? C'est dans le cadre de la nouvelle loi, il est permis aux entreprises publiques et à l'État de compromettre, ce qui n'était pas permis sous l'ancienne loi. Mais l'État ou les entreprises publiques peuvent compromettre uniquement dans leurs relations économiques internationales et également dans le cadre des marchés publics. Ce sont les deux exceptions où l'État, ou les démembrements de l'État, ou les entreprises publiques peuvent intervenir au niveau de l'arbitrage. Mais il est à noter, j'en ai discuté avec certains membres aujourd'hui, hier, que malheureusement, et c'est ça le plus important, je crois que c'est le point nodal, c'est qu'il n'y a pas encore une culture avérée de l'arbitrage et que cette culture est encore embryonnaire malgré, si vous voulez, tous les efforts que fait la Chambre de commerce et le centre à travers des conférences, à travers des symposiums, à travers des manifestations où on plaide pour l'arbitrage. Et, bien entendu, en partenariat, notamment avec la Chambre de commerce, le centre de Milan, etc., on a essayé de booster, excusez-moi le terme, l'arbitrage, mais pour revenir à l'Italie, la patte arrive à prendre difficilement. Mais la volonté et la persévérance sont toujours intactes, tant au niveau de la CACI que du centre. Alors, cela n'exclut pas, bien entendu, les problèmes des coûts de l'arbitrage. Et, actuellement, on s'entend dire à toutes les conférences combien coûte l'arbitrage. Combien coûte l'arbitrage. Et c'est une question nodale et rédhibitoire. Et je vais m'efforcer en quelques minutes de vous expliquer quelle est notre expérience à ce niveau-là. Alors, bien entendu, comme dans tout centre, j'irai rapidement, il y a des frais d'enrôlement, c'est ce qu'on appelle nous les frais administratifs. Actuellement, ils sont uniquement de 500 € l'inscription. Sorry? Ah, ok.
I would raise, I would ask the question.
Ok, d'accord.
And the administrative costs and other relevant questions.
Ok. Alors, on les laisse pour les questions. Hein? Alors, alors, bien entendu, il y a le problème des honoraires des arbitres et des frais d'arbitre. Alors ici, bien entendu, les honoraires des arbitres sont fixés par le tribunal arbitral. C'est le président, en collaboration avec le comité d'arbitrage, parce que pour comprendre ce système, il y a un centre, il y a deux organismes. Il y a un organisme qui s'appelle le comité d'arbitrage, c'est lui qui gère tous les problèmes d'arbitrage, et il y a un secrétariat. Donc c'est le comité d'arbitrage qui, avec le centre, avec le secrétariat, et le président qui fixe les... Oui. Ok, d'accord. D'accord. Alors, bien entendu, alors si on va aller rapidement, il y a des provisions qui sont payées. Les provisions, elles doivent être payées par les deux parties. Malheureusement, actuellement, le problème, c'est que les provisions, certaines parties refusent de les payer. Et donc, nous avons pris une décision que si l'arbitrage doit continuer, il faut qu'il soit supporté par l'autre partie. Les honoraires, il a été décidé que les honoraires soient le plus bas possible. Pourquoi? Parce que la philosophie du centre est que si on veut arriver à développer l'arbitrage, il faut nécessairement que les honoraires des arbitres ne soient pas trop élevés. Et c'est pour ça que j'ai donné deux exemples concrets. Un arbitrage dévolu au centre entre une entreprise publique et une société privée qui a été tranché par 3 arbitres algériens. Le lieu de l'arbitrage était Alger pour un montant de 150 millions de dinars, c'est-à-dire 1,5 million d'euros. Ça coûtait en honoraires d'arbitre et frais à 3 millions de dinars, c'est-à-dire à moins de 30 000 euros. Vous voyez que finalement, la tranche était vraiment très très basse. Tout cela pour inciter les gens à aller vers l'arbitrage. Dans un autre cas, il y a un arbitrage de nature internationale sur un différend opposant une société étrangère à une administration locale qui devait être tranché par 3 arbitres algériens, avec 16 à Alger. Le montant réclamé par le demandeur à l'arbitrage était de 48 millions de dollars. La provision pour chacune des parties a été fixée uniquement à 2 millions de dinars, c'est-à-dire 20 000 euros. Malgré la modicité de cette somme, une des parties, la partie algérienne, a refusé de payer sa quote-part et la provision a été supportée par la société étrangère et c'est ce qui a permis d'aller vers cet arbitrage. Alors, les honoraires des arbitres, nous avons fixé un calcul et on répartit sur le montant total. Par exemple, les 3 millions ou les 20 000 euros. Une partie, 25% de ce montant revient au centre. Pourquoi? Parce que le centre est financé par la Chambre de commerce. Donc forcément, une partie des frais pour rembourser le secrétariat, tous les frais préparatoires sont supportés par la Chambre de commerce. Donc pour rembourser, on prend une partie de ces frais et on les reverse au centre qui fait son affaire avec la Chambre de commerce. Le reste est partagé entre le président à hauteur de 40%, un peu moins de 40% et 30% de chacun des 2 arbitres. Mais il est à noter que même sur ce montant, une partie revient au secrétariat pour les travaux supplémentaires accomplis par le secrétariat et une partie va également à ce qu'on appelle le rapporteur. Parce qu'au moment quand une affaire arrive, que le comité prima facie a décidé que c'était une affaire arbitrale, elle est dévolue, donc il y a un rapporteur qui est désigné et ce rapporteur est également rémunéré. Bien entendu, les frais sont remboursables sur justificatif. Et même au niveau des frais, on demande à ce qu'on ne mette pas n'importe quels frais, les frais essentiels, toujours tout cela pour faire diminuer les coûts et apporter les gens à venir vers l'arbitrage. Alors, bien entendu, rapidement, les frais des honoraires et des experts. Alors, si un expert est désigné par les parties, actuellement, la jurisprudence du centre, c'est de faire supporter les frais des experts par les parties. Si c'est le tribunal qui désigne un expert, c'est lui qui va le prendre en charge. Même chose pour le traducteur. Si c'est un traducteur qui est désigné par les parties, elles vont supporter les frais de cette traduction. Si c'est le centre qui le désigne, à ce moment-là, le centre prend en charge et après, au moment de la sentence finale, il va déterminer sur qui reviendra cette charge. Bon, alors, maintenant, on revient aux frais de la défense, c'est-à-dire des avocats. Nous avons décidé, toujours dans cet esprit, de pouvoir ramener les gens à l'arbitrage. Pourquoi ? Il faut comprendre que pour nous, l'arbitrage ne peut prospérer que s'il concerne les petites et moyennes entreprises. Pourquoi ? Parce que les grandes entreprises qui ont les moyens n'ont pas besoin de venir, j'allais dire, à l'arbitrage institutionnel. Elles signent des contrats importants, je prends l'exemple de Sonatrach, et ils vont mettre une clause, une convention d'arbitrage qui va régler tous les problèmes. Et généralement, cette société Sonatrach est connue qui a eu pratiquement 50 dossiers d'arbitrage de nature internationale, sont pris en charge donc directement par l'entreprise, et ce n'est pas les moyens qui manquent. À ce moment-là, elle choisit ce type de... Donc, c'est pour ça que je vous disais que l'arbitrage concerne pour nous surtout, on veut cibler les moyennes et les petites entreprises de venir vers l'arbitrage, et quand même, ça commence à prendre, et c'est pour ça qu'on dit qu'au départ, nous préférons que même les frais d'avocat soient pris en charge par les parties dans un premier temps. Je voudrais souligner aussi que les coûts de l'arbitrage, les frais, etc., en principe, sont fixés par le règlement d'arbitrage. Mais actuellement, nous sommes en train de revoir le règlement d'arbitrage. Celui-ci, je pense, sera prêt à la fin de l'année. Et à ce moment-là, on fixera un barème aussi bien, on fera une juste proportion en rapport avec le montant du litige, les frais véritablement engagés, et peut-être à ce moment-là, on inclura les frais des avocats. Alors, qui doit supporter la charge des coûts ? Alors, il appartient au président du tribunal, en concertation avec ses co-arbitres, de décider dans la sentence finale laquelle des parties supportera les frais d'arbitrage. Alors, qu'est-ce qu'on fait ? La pratique actuelle, c'est que si une partie a succombé, on va lui rembourser, on va lui payer la part du principal qu'elle a réclamé. Mais quant aux frais, on va faire une sorte d'opération. Les frais d'avocat, on va les laisser à la partie même qui a gagné, mais certains autres frais, il reviendra à la formation arbitrale de décider si la partie qui a obtenu gain de cause dans cet arbitrage aura ou non à les supporter. Bon, bien entendu, il y a des arbitres étrangers. Il y a des arbitres étrangers qui viennent pour certains arbitrages en Algérie. À ce moment-là, comment que ça se passe ? Bien entendu, la formation arbitrale décide des frais qui vont revenir à cette personne, et bien entendu, à ce niveau-là, on agit au cas par cas. Pourquoi ? Parce que nous avons un problème récurrent en Algérie, c'est que même si vous devez payer un arbitre en monnaie étrangère, on doit avoir préalablement l'accord de la Banque centrale. Ça rentre dans le cadre du contrôle d'échange et ça pose un problème. Mais il évolue puisque nous sommes en tractation avec la Banque d'Algérie pour réformer ce règlement bancaire au sujet des frais exposés par les arbitres étrangers. Les coûts additionnels. Rapidement, vous savez que, comme je pense dans tous les systèmes, lorsqu'une sentence a été rendue, on peut se retrouver devant un tribunal il y en a qui demandent l'annulation de la décision. Il peut y avoir aussi ce qu'on appelle des mesures conservatoires réclamées par une des parties par rapport à des mesures conservatoires devant le tribunal judiciaire. À ce moment-là, bien entendu, ça va générer des coûts supplémentaires et nous le faisons supporter par... mais ça, c'est, si vous voulez, pour les mesures conservatoires, c'est en amont. Donc à ce moment-là, on décide. Mais pour les décisions d'annulation, etc., c'est des coûts additionnels pour lesquels le tribunal ou le centre n'a plus rien à voir parce que c'est postérieur à la sentence. Enfin, en conclusion, je vais dire qu'il est certain que cette situation évoluera avec le développement de l'arbitrage en Algérie et l'adoption du nouveau règlement d'arbitrage du centre. Je voulais revenir aux arbitrages, à peu près 51 arbitrages de la plus importante société algérienne qui fait vivre 98% de la population, c'est la société Sonatrach. Elle a eu 51 arbitrages, dont 95 avec ICC, la Chambre de commerce internationale, mais jusqu'à présent, on n'a jamais su quels étaient les montants qui ont été exposés dans le cadre de ces arbitrages. Et la philosophie du centre actuellement, c'est de réclamer une aide, bien entendu, c'est au cours de séminaires, au cours de travaux de méthodologie, d'approche, etc., nous sensibilisons aussi bien les arbitres que les avocats des parties qui ont affaire à l'arbitrage de modérer leurs honoraires pour nous aider à réussir la bataille que nous menons, c'est-à-dire faire développer l'arbitrage en Algérie. Je vous remercie pour votre attention.
Thank you. Thank you. And now the third speaker is Mr. Mohamed Abdel Raouf. Mohamed is director of the Cairo Regional Center for International Commercial Arbitration, and he is one of the participants of the ISPRAMET project. So I kindly request him to present their system without much saying on cost of arbitration, okay?
Yes, sir.
Just introduction of
Understood.
the system.
Thank you very much, Professor Uzunay, and thank you for giving me this opportunity to come to Istanbul. It is always a pleasure. I have the privilege of running the Cairo Region Center, which is an international organization established since 1979, an old institution, more than 30 years of existence. When this institution was established, two decisions were taken. First, to have our rules based on the UNCITRAL rules, for obvious reasons. Second decision was to encourage arbitration and promote it by having attractive costs. Attractive costs relating to arbitrators' fees and also to admin fees. I have to tell you that while this was valid during the establishment phase, we have realized years later, when our activities have developed, that it is not, we had to review our schedules on costs. We were regarded as being one of the cheapest arbitral institutions worldwide. This was not very good for the reputation of any arbitral institution, especially after many years of existence. So, to introduce our system, it has been reviewed in 2011 based on two types of statistics. Statistics that are particular to the institution, what are the number of cases that we have, the amounts of dispute, in dispute that we have in such cases, and also general statistics, some of which were introduced this morning, according to which I refer you to a very interesting survey conducted by Queen Mary and White case in 2010, whereby we realized that the first influence for choosing or selecting an arbitral institution is not costs. It is neutrality, 66%, followed by reputation and recognition, 56%, the arbitral rules of such institution, the law governing the merits of the dispute, previous experience of the institution, and number 6, costs. This, along with other surveys concerning the proportion or the most important element of costs in arbitration, it was also said this morning, 74% of costs of arbitration relate to legal costs, attorney's fees. So for an arbitral institution like ours, we were sure that admin fees and arbitrator's fees are not the most important elements in selecting arbitration under our auspices. So we have 3 schedules, and I will tell you very briefly. One schedule relating to admin fees. As Stefano has mentioned, we adopt the ad valorem approach. Based on the amount in dispute, we calculate the admin fees. Same applies to arbitrator's fees, with one particularity that, according to our statistics, we have deemed it fit to have 2 schedules for arbitrator's fees. One for arbitrations in which the amount in dispute does not exceed $3 million. Here we have an ascending flat rate. Another schedule is for arbitrations where amounts in dispute exceed $3 million. In such a case, we have the scale minimum, average, and maximum. Thank you very much.
Thank you, Mohamed. Now, the next speaker is Mr. Muhyiddin Al-Kaisi. Muhyiddin is Secretary General of the Lebanese Arbitration Center in Beirut. So you have the floor, dear colleague. Outline.
Thank you, Mr. President. Ladies and gentlemen, there is no doubt that in these days we can no longer reasonably preach, as we used to do in the early days of the rise of arbitration as an alternative method of dispute resolution, that having recourse to arbitration rather than to national courts would save the parties time and money. To the contrary, more and more today we are hearing users of international arbitration complaining that it takes too long and it costs too much. And it has become obvious that indeed we are witnessing a major increase in the cost of arbitration in general and international arbitration in particular. The high cost is mainly due to the length and complication of arbitration proceedings, which often seem to be unnecessary and avoidable. And while it is true that the largest portion of such cost is constituted by the cost incurred by the parties in the presentation and defense of their case before the arbitral tribunal, as opposed to cost in relation with the arbitration institution managing the case, there is still a role that those arbitration institutions can play in order to contribute to a better case management, leading to effective cost control. In fact, many arbitration institutions have started initiatives in that direction. To name but a few of those initiatives, the ICC published suggested technique for controlling time and cost in its first edition in 2007 and second edition in 2013. And its revised 2012 rules introduced some provisions which could help in reducing the time and controlling the cost of the arbitration process. Example, 1, new ICC rules require parties to provide more information upfront to to expedite early processing of a case. Second, ICC court now has direct powers of appointment if a national committee fails to do its job promptly, or where one of the parties is a state entity. ICSID has also introduced numerous efficiency initiatives in recent years, which have resulted in a remarkable reduction in the average duration of cases. Example, ICSID has reduced the average time to register a case as well as to constitute the arbitral tribunal, and statistics show that disputes concluded during ICSID 2011 fiscal year took an average 12 months less than cases concluded during the previous years. In that sense and direction, arbitration institutions should be invited to consider taking some of all of the following initiatives. First, encouraging or requiring the inclusion of more information and details in the request of arbitration and answer, such as the legal basis as well as the value of the claim, so that the parties will be in a better position to manage the presentation of their case from the outset and thus keep the exchange of submissions to a minimum. Second, when appointing arbitrators, making sure that the potential candidate is available and has sufficient time to devote to the case and proceed with it in a timely and efficient manner. Examples: 1. The ICC now requires arbitrators to provide data about other cases in which they serve. Second, the Lebanese Arbitration Center requires the arbitrator to sign a declaration of availability along with the Declaration of Independence. Third, before proposing arbitrators to the parties, ICSID asks them to confirm sufficient availability in the next 18 to 24 months. Third, giving incentives to the arbitral tribunal to be efficient by taking into consideration, when fixing the arbitrator's fees, their diligence and timeliness in conducting the proceedings and submitting the award. Fourth, giving incentives to the parties to be efficient by encouraging the arbitral tribunals to take into consideration the effectiveness and non-use of dilatory tactics by the parties during the proceedings when allocating the cost. Fifth, encouraging or even requiring the arbitral tribunal to consider and rule on jurisdictional national matters before looking into the merits, as it would avoid incurring significant costs in addressing unnecessary issues of liability in cases where the arbitral tribunal would finally refuse jurisdiction. Example of Ruby Rose Agricole and Qasim Omar versus Kazakhstan Unicitral Award on jurisdiction rendered on the 1st of August 2013, in which the arbitral tribunal refused jurisdiction in final stage of arbitration. 6. Encouraging the use of available technologies that contribute to accelerating the process and reducing its cost. For example, using emails instead of regular courier, using video conferencing instead of traveling and for hearings and or meetings, etc. Moreover, it should be pointed out that promoting and encouraging the recourse to regional arbitration institutions which are closer to the location of the dispute is also crucial and can highly contribute to limit the general cost of the arbitration process. With that in mind, the Lebanese Arbitration Center at the Beirut Chamber of Commerce and Industry has recently introduced some modifications in relation with the general cost of the arbitration process. Indeed, on 17 September 2013, the Center has published a new table clearly fixing the arbitrator's fees as well as the administrative cost, so that the parties wishing to start arbitration proceedings before the Center would know from the outset the cost that they are going to incur. This step will contribute to introducing more predictability and transparency to the arbitration process, which could in turn help to lead the users of this process to have more comfort and trust in resorting to arbitration before the center for the settlement of their dispute. We will conclude by saying that reducing the time and cost of the arbitration process should be a major concern of arbitration institutions, as this will contribute to maintaining the success of the arbitration process as a preferred dispute resolution mechanism. Thank you.
Thank you, Muhyiddin. I have forgotten to say his role regarding the establishment of another Mediterranean arbitration project. Muhyiddin is one of the most influential actors regarding the ASCAME Mediterranean Arbitration Center. So approximately 4 or 5 years before, together with him, we had prepared the outlines of the ASCAME Arbitration Center, but unfortunately, it is still waiting. Now, the last one, Senem. Senem is the last but not least. Senem is a member of the Istanbul Bar Association, and at the chamber, one of the chamber's councils, in-house council. Her responsibility here mostly to follow the developments regarding the ASCAME, the ISPRAMET work and also domestic arbitration. So she would present us outlines of the current Istanbul Chamber of Commerce arbitration system. Yes, your turn.
Thank you. The costs, according to our regulation on arbitration, mediation, and export Thank you. According to our regulation on arbitration, mediation, and export arbitration costs regulation, we are, the fee for mediation service, mediation arbitration, and export arbitration is 66 Turkish liras, which is around $30. Then there is this advance payment, advance to be deposit by the claimant, which is 1,000 Turkish liras, is to be once the then there is the arbitrator's fee. The arbitrator's fee is 1% per arbitrator, 1% of the disputed amount per arbitrator. Once this advance is deposited and the arbitrator's fees is deposited by the claimant, then the arbitration bureau delivers the statement of the claim to the respondent. Otherwise, the bureau does not deliver the claimant, and then the arbitral tribunal may suspend the arbitration proceedings. And once the arbitral tribunal suspended the proceedings, then if within 1 month upon the notification to the parties of the suspension, if it's not deposited, then the arbitral proceedings shall terminate. Otherwise, the proceedings shall proceed. This is the cost, our regulation on costs. Just about this. Thank you.
Thank you, Senem. So, dear colleagues, we have heard the outlines of several systems around Mediterranean. Now I am coming to several concrete questions, issues related to the cost of arbitration. So we would focus on some concrete issues related to arbitration costs. My first question would deal with the definition of cost. So the items included by the concept of cost, which items are included in each arbitration system. So let us begin again with Stefano. So Milano, and then let us continue with Algeria. So Stefano,
Yes.
your
Cost for the Milano rules are administrative costs that they cover the institution's activity and the arbitrator's fees, that they cover the arbitrator's honorary for their activity. Then in the administrative costs, they are included hearing rooms, secretarial activity of the center, and all the administrative organizational actions. In the arbitrator's fees are not included travel expenses, accommodations, that of course they are living expenses that they had to be added. They are, costs are also, administrative costs, arbitrator's fees, and experts' fees, if there is any expert to be appointed. That's something that has to be added. Then all the other costs, additional costs, are not included, like translators, like stenotypists, and all the other organizational activity. These are the costs according to our rules. I think it's not very different than any other system. So.
Thank you. What about in Algeria? So the composition of the cost. Yeah.
Oui. Alors, merci Monsieur le Président. Non, ça va. Pour les frais administratifs, pour nous, les frais administratifs qu'on paye au début de l'enrôlement de l'affaire sont acquis au centre. Le seul fait d'enrôler cette affaire impose des frais qui sont évalués actuellement à environ 500 €, c'est-à-dire 50 000 dinars algériens. Si ces frais ne sont pas payés, il n'y a pas, on n'enregistre pas la requête. Quand ils sont payés, si par la suite il n'y a pas on ne donne pas suite à la requête, les frais sont quand même acquis au centre. Ça, c'est le principe. Par la suite, ces frais, donc je disais, ils vont directement au centre et ils concernent uniquement l'enrôlement. Par la suite, il y a les frais, les premiers frais. Ce qu'on appelle, on fait payer une avance, qu'on calcule par rapport aux frais que ça va engendrer la procédure. Et cette avance est payée en principe par les deux parties. Bon, comme je l'ai expliqué précédemment, si une des deux parties ne paye pas, etc. Et pour en revenir au coût global de l'arbitrage, les frais administratifs ne sont pas pris en compte. Pour nous, ce qui revient, qui va entrer dans le décompte des coûts, c'est les frais des arbitres, les frais des experts désignés par le tribunal et les frais des traducteurs désignés par le tribunal. Voilà les frais tels que nous les avons envisagés et qui seront encore en cours pratiquement jusqu'à la fin de l'année. Et nous avons décidé, le centre avait décidé que, bien entendu, les frais de la défense ne sont pas pris en compte. Donc, on n'a pas un problème de compter. Bon, maintenant, il y a une question qui se pose et que nous allons mettre en application, en principe, à partir de l'année prochaine. C'est quoi? C'est, comme disait Mohamed Abderraouf, il y aura une valeur ad valorem, il y aura un pourcentage par rapport à la demande d'arbitrage. Il y aura un pourcentage par rapport à la valeur d'arbitrage. Bon, bien entendu, il va se poser aussi une question qui n'a pas été traitée ce matin, mais je pense que notre confrère pourrait peut-être en dire deux mots, c'est les coûts de ce qu'on appelle les demandes reconventionnelles. Alors, généralement, je me suis aperçu que dans certains pays, on ne parle pas des frais des demandes reconventionnelles. Or, les frais reconventionnels, non pas les frais, excusez-moi, les demandes reconventionnelles, elles peuvent être également calculées et avoir un coût qui pourrait se surajouter aux frais préliminaires, etc. Mais tout cela, bien entendu, sera étudié et mis en application avec l'application, excusez-moi de me répéter, du nouveau code, du nouveau règlement d'arbitrage qui verra le jour en début de l'année 2014.
Okay.
Okay.
Yeah. With regard to arbitrators' fee, I would like to raise another question. What about the value-added tax with regard to arbitrators' fee? The second, yeah.
Well, if they are due, then we have to collect them. So our fees, then, if they are due, any fiscal obligation or VAT obligation has to be added to the fees. But sometimes they are not due because for some reason the arbitrator is not a VIT, let's say, subject. So it's something we cannot, if they are due, they are due. There is very little to do.
What about in Algeria?
Alors, pour la TVA, en principe, 99% des arbitres sont des avocats. S'ils ont travaillé dans une affaire d'arbitrage, ça devient des honoraires pour lui. En principe, il doit les déclarer dans son chiffre d'affaires et bien entendu, il est soumis à la TVA. Bon, quid des personnes qui ne sont pas avocats? À ce moment-là, en principe, la loi fiscale, elle est claire. Tout revenu doit faire l'objet d'une retenue fiscale. Donc, en principe, tout arbitre doit être soumis à la TVA. Thank you, Mr. President.
Thank you. Another question again with regard to the arbitrator's fee. So, under your system, are arbitrator or arbitral tribunals entitled to employ an administrative secretary? And if so, who pays the fees and expenses of the administrative secretary of the arbitral tribunal?
Well, according to our rules, actually, our rules are silent on this issue because our system provides for secretarial assistance by the center. So it's included in the cost of arbitration, also the secretarial assistance by the institution. If a panel or a sole arbitrator or a tribunal wants to use a secretary, we have nothing against, we do not encourage, but for sure that cost should not go to the parties. So if they want to appoint a secretary, they can do it, but parties cannot pay more than what the schedule of fees of our rules says. So it's on arbitrators' cost.
Yeah, okay. What about?
Alors, pour nous, dans les 25% qui est pris sur les revenus qui reviennent aux arbitres sont versés au centre. Dans ces 25%, il y a 5% qui revient au secrétariat administratif et aussi ce que j'ai appelé tout à l'heure le rapporteur qui est désigné par le comité d'arbitrage. Et également, une partie de ces 5% revient aux membres du comité d'arbitrage qui ont revu la décision. Pourquoi? Nous considérons que les membres du comité d'arbitrage, pourquoi? Parce que nous avons un article 15 qui dit qu'avant de rendre la sentence, celle-ci doit être présentée au comité d'arbitrage qui fait une relecture. C'est surtout pour la forme, pour voir s'il n'y a pas des erreurs, etc. Il ne se prononce pas sur le fond. Il se prononce sur la forme, peut-être certaines erreurs, etc., qu'il corrige. Et pour ce travail, dans ces 5%, ils sont rémunérés par ces 5% qui restent par rapport, qui sont délivrés au centre, à la chambre par le centre.
Okay, thank you. Now, Mohamed, I am directing the same questions to you, including these two last questions.
Okay, I might have forgotten your questions, but I have noted them down. So allow me to ask you if I have forgotten one of your questions. We define two things as an arbitral institution. Costs, this was your first question. Registration fees, we charge US 500 for claims and counterclaims. If you file a counterclaim, you also pay registration fees. We have, of course, admin fees and arbitrators fees. And also, we have deemed it fit to say that costs include legal costs. Let me give you an example to give you the regional flavor. In Dubai recently, the rules do not indicate that costs include legal costs. Normally, arbitral tribunals are requested to award legal costs. Sometimes they request submissions on costs, and they award legal costs. Dubai Court of Cassation very recently indicated that since the rules of the Dubai International Arbitration Center does not include in the definition of costs legal costs, then arbitral tribunals acting under the auspices of such institution cannot award legal costs. This gives you an idea about the importance of maybe including legal costs in the definition of costs. One last thing, we also define what is the amount of dispute. As Mr. Bin Qasim mentioned, it is extremely important to say how do you calculate the amount in dispute. It's very simple. It is the aggregate value of all claims, counterclaims, and also set-offs. Thank you very much. This is the first question. Second question relates to VAT. Well, we are an international organization. We are exempted from such any taxes, our services, but of course fees of arbitrators are subject to the national laws. Secretary to the tribunal. We don't have any indication in our rules to secretary to the tribunal. We have to be very clear. There is a distinction between case management, which is offered by the institution. The institution manages your case against admin fees, and secretary of the tribunal. This is an option that a tribunal can have. Normally, a member of the chairman's law firm or the chairperson's law firm, and this would be either against fees for such secretary or for free. It's left to the arbitral tribunal to decide, and we don't have a provision regarding this. I think you had a third question, but I have forgotten. What? Any other question?
Value-added tax.
Yes, I already mentioned that we don't have.
And then these two.
Thank you.
So, the same questions to you. Yeah.
Actually, we have also the same as in Milano. We have a registration fees, $1,000 US, plus 10% VAT. We are paying the VAT on behalf of the arbitrators. They are not going to pay another amount of VAT. Only the center will collect the VAT and pay it. Now, according to Mr. Muhammad, he said that no VAT for the center because it's an international law center. But what about if the arbitrator was a lawyer and he is subject to VAT? Is he going to pay the VAT to the government? If you are not, you are exempted from VAT. Now in Lebanon, we are not exempted from VAT. We pay the VAT on behalf of the arbitrators. Any amount collected from the parties, we pay for it the VAT, and the arbitrator, when he'll collect his fees, he'll never pay any VAT to the government. We have registration fees, $1,000 US plus 10%. We have administrative fees for the center. We have expert fees paid by the parties if needed, if they need experts. and the arbitrator's fees. We offer for free all the logistic facilities, the conference room for the proceedings, the secretariat, if needed by the panel, typing the minutes of the meetings, or the award if needed, coffee break, tea break, etc., are offered for free by the center if the proceedings took place in the center.
Yeah, okay. Thank you. Yeah, Senam, what about the cost of arbitration under ITO system?
Okay.
Filing fee and the other costs, I mean.
As I explained to you before, the registration fee is 66 liras, and there is this advance payment of 1,000 liras, and then the arbitrator's fee. In international and domestic arbitration law, the arbitrator or the tribunal is required to indicate in the arbitration in the award the arbitration costs, which the arbitration costs include fees of the arbitrators, fees, travel costs, and other expenses incurred by the arbitrators, fees paid to the experts appointed by the arbitrator tribunal, or to the other people whose assistance is required, or the on-site inspection costs. Then there is also travel costs or other expenses of the witnesses, to the extent that such expenses are approved by the arbitral tribunal. And then there is the attorney fees for the prevailing party, which is determined in accordance with the minimum attorney tariff fee. And the official charge for application to the state courts also included in the arbitral awards. And then the notification expenses are indicated in, should be indicated in the award. And unless otherwise agreed by the parties, the arbitration costs are shall be borne by the losing party according to Turkish law.
Good, thank you. Now, I am coming to the next question. Again, I am going to focus on the arbitrators' fees. When you calculate the arbitrators' expenses, not fees, but expenses, do you follow the principle of reasonableness, or what kind of criteria do you apply with regard to the expenses?
Well, to the expenses, we give to the arbitrators indications on which kind of expenses will be covered and which shall not be covered. If they fly from Paris to Milano, they must fly economy. Because otherwise the cost can be extremely high for disputes that should be, should not cost much. Then as far as hotels are concerned, in Milano we have some agreement with the 4 or 5 stars hotels, so very nice, but with the rates that they are in some way preferential. And so the arbitrators are free to go everywhere, but if there is an increase of cost compared to the hotels that they offer privilege rates to the chamber, then the difference is on the arbitrator's cost. So we try to give them, instruction on what should be covered. We believe that is more than decent what is covered. Yeah. Then if they want to fly first class and stay in an 8 stars hotel, because maybe there is one 8 stars hotel in Milano, they can do it, but they pay the difference.
Yeah. I see. So
more or less, yes.
Yeah, it seems that the principle of reasonableness prevails.
Yes.
Yeah. Okay, good. What about in Algeria?
Alors, les frais, premièrement, ils sont contrôlés, ils sont vérifiés. Et comment qu'on arrive à mieux les vérifier? C'est avec l'agenda. Quand vous faites votre acte de mission, vous avez un agenda par rapport à toutes les audiences, tous les rendez-vous, etc. Donc à partir de là, il y a une traçabilité. Il y a une traçabilité pour tous les frais. Et nous demandons bien entendu que les frais soient dûment justifiés, et bien entendu, toutes les dépenses inutiles, elles ne sont pas prises en compte. Les dépenses inutiles ne sont pas prises en cause. Et bien entendu, même au niveau des hôtels, etc., on connaît pratiquement... Je vais prendre un petit exemple. À Alger, on connaît pratiquement tous les hôtels où on peut aller tenir des réunions, etc. Donc, on connaît les prix. On ne peut pas, si vous voulez, le terme, excusez-moi, se faire avoir, etc. Bon, mais très souvent, c'est la chambre qui produit le lieu de l'arbitrage, elle produit les repas, les pauses café, tout ça, si vous voulez, rentre dans ces fameux frais administratifs dont j'ai parlé au début. Donc, si vous voulez, il y a certains frais qui n'existent plus pour les arbitres, et donc c'est uniquement les frais qui sont justifiés, qui sont remboursés aux arbitres.
If I just give you one example, we really control cost. When the arbitrators send us at the end of the arbitration the expenses, we do control. It happens once that an arbitrator, that's some way funny because he asked a reimbursement for 3 nights hotel, a room for one hearing of 1 hour, 3 nights in Milano, for him and for the son. There was, the son was not involved in the arbitration. He was probably in Milano for other reasons. He claimed a reimbursement that we, of course, refused. Then he apologized. He said, sorry, it's my secretary. It's always the secretary's fault. I didn't intend to give reimbursement for my son for 3 nights. It's only 1 night for myself. And that's what he got. So we really check. Because we own to the parties. We cannot just...
Do you usually check the invoices, for instance, after a lunch or dinner?
We do.
Expensive wines or...
well, that is a little difficult because Italian wine can be very expensive. So what we do, we check if there is a restaurant bill for 8 people and it's only the arbitrator, we don't reimburse. I mean, we challenge the request.
But table wine, okay.
Table wine, yes. Then that's a crucial, it's a difficult issue because, But,
okay.
but we give,
check,
we want to deliver is the message to the arbitrator that our eyes are open. Then most of the time there is a self-control, most of the time, because they know that they are, in some way supervised, and most of the time they behave because they know to be supervised.
Okay.
But it can be delicate.
You also check the invoices or receipts.
Yes,
Yeah, you see.
of course. Mais comme je disais, on n'a pas tellement de problèmes. Pourquoi? Parce qu'il y a une sorte d'unicité du lieu de l'arbitrage. Ça fait que les arbitres, pratiquement, se trouvent au même endroit. On prépare un ordre du jour, on prépare tout ça. Donc, il n'y a aucun souci. Sauf l'arrivée d'avant-veille, bien entendu, de l'audience, où, effectivement, l'arbitre peut aller manger là où il veut, etc. Mais de ce côté-là, on n'a pas un problème. Bon, on va parler du problème du vin. Effectivement, je sais que le vin va toujours poser des problèmes dans l'arbitrage. Enfin, on n'a pas tellement de ce problème-là parce qu'il y a certains arbitres qui ne veulent pas savoir s'ils boivent ou pas. Alors, de ce côté-là, on est tranquille.
Okay, thank you. What about your attitude, Mohammed, in Egypt?
We don't have per diem given to arbitrators.
With regard to board and accommodation?
Yes, for expenses, some institutions, as you know, they give you a per diem or the option of having a per diem. We don't do that. We have received certain requests in order to consider having a per diem rather than following and inspecting and so on and controlling the invoices. However, the practice that we are having is to reimburse based on actual costs and to control invoices. We also have, as in Milano, as in Algeria, deals with five-star hotels where you have a limit for your day-to-day expenses, and any excess would be reported to the center. May I tell you also that our admin fees, like in Algeria and in Lebanon, they cover the hearing rooms. And also, we have our admin fees are capped. The maximum admin fees that you can pay, regardless the amount in dispute, is $50,000 US, even if you exceed amount in dispute $100 million US.
Do you have a practice with regard to arbitrators' board and accommodation? For instance, instead of actual expenses, do you give a lump sum amount, for instance, let us say $500,
No.
do
As-
everything
as-
what
as-
you would like?
As I mentioned, per diem and lump sum amounts are not.
Also, you have that?
We don't have that.
You don't have that?
We don't
I
have that.
see. So always you take
Upon
into account
invoices.
actual.
Costs
Okay.
upon invoices.
Okay. What about in
We
Lebanon?
have the same, we have to distinguish between domestic arbitration and international arbitration. Normally, most of our arbitration are domestic. 80% of our cases are domestic arbitration. And should we have international arbitration, around 20%, mostly the arbitrators are Lebanese, chosen by the parties, even in international arbitration. They don't need any accommodation, and for this reason, we don't have ni per diem, ni accommodation at the. We had sometimes arbitrators from France. We pay for them because they have their home in Lebanon. We pay for them the travel ticket.
I see. So, Senan, what about the generosity of your system?
In our regulation, we don't have any provision in respect, and 90% of our cases are domestic cases. We have few international cases, so we don't face lots of arbitration cases which requires expenses. So, but I believe that the principle of reasonableness should be, followed in case.
Okay, thank you. Now, the last two questions, because we have only 10 minutes. The first one is who has to pay the arbitration costs? For instance, only unsuccessful party, or equal payment by the parties, or each party has to bear its own expenses? What is your rule or practice, case law?
Advance cost has to.
No.
I talk too much. I'm not working anymore. I use Algerian microphone. Thank you for.
Mediterranean.
We use their gas, their oil, and also the microphone. The advance on cost are paid by the parties 50-50. No question. Then if one of the party does not pay, then the other party can cover. This is an advance on cost. The final cost, as I said, it's not our business. It's something that is decided in the award by the arbitrators. Usually, I would say that it follows the decision. If someone loses, then we'll cover entirely the cost. The practice, in reality, is a little different. There is this practice that personally I don't like much, is to not to use, just to use Andrea's comment, not to use properly that power. So sometimes I think that arbitrators are a little too shy to say, maybe on the merit they say white, black or white, but then when they come to cost, Legal costs, most of the time they say that each party will take care of their own legal cost. And as far as arbitration costs are concerned,